You're watching The Business of Law, brought to you by Bloomberg Law and the ABA Journal. I'm Lee Pacchia. As more large law firms feel the need to reduce headcount, some are looking to their partnership roles to make the cuts. Joining me now to walk through the hows and whys behind this emerging trend, I'm happy to say we have Kent Zimmermann, law firm consultant at the Zeughauser Group. Welcome back.
Thanks for having me.
Of course. So we've seen a number of large law firms laying off staff and attorneys recently. Most notably, of course, Weil Gotshal last month terminated 110 staffers, 60 associates, and they significantly cut compensation for 30 partners. Not something we see normally. Back in January, you predicted on this program that partner layoffs were coming for many big law firms. How many AmLaw 100 firms have you heard either have or will be terminating partners this year?
So what I would start by saying is that almost all, maybe all firms in the AmLaw 100 would like to be financially stronger than they are. Even the strongest have challenges. It's all relative, as they say. What I would point out, though, is for many, many firms, reducing chronically underperforming partners, as well as reducing chronically underperforming offices and practices, is part of the strategy to improve their financial performance. And not addressing those chronically underperforming parts of the firm would be like Procter & Gamble having business units that are chronically underperforming and saying, you know what, it's not in our culture to cut anything. That would never happen at a P&G, and at the strongest law firms, doesn't happen there either.
Is it firms with particular practice areas that need to call the partnership roles, or is it firms needing to look across the ranks?
Many firms are looking across the ranks. However, there is definitely a trend towards decreasing reliance and actually shedding low-rate practices. I'll give you an example. It's no coincidence that a number of firms have recently shed their trust and estates practice. Wilmer did it, Wilson Sonsini did it, Debevoise here in New York did it, many others. Those all happened relatively recently, and it's not any secret that the reason why they did it is they want to focus on their high-rate areas of practice relative to their low-rate areas of practice.
It's tough to look at these particular situations. There's two ways you can see it. On one hand, you can see partner cuts as a sign of desperation that the firm has run out of easier cuts to make. At the same time, it can be the sign of smart management. How do you see this playing out?
So more often than not, when we see cuts of chronically underproductive partners, we see that as a sign of strength and an improvement in the firm's financial performance. In other words, it's a way of valuing performance, financial performance, over size. That's healthy. So when we see that happen, we're glad to see it happen. The strongest firms, on an ongoing basis, look at their partners. They set expectations for how many hours the partner should be working. Back in the boom years, the average hours across the AmLaw 200 were about 1,750. We're down to an average of about 1,640. Firms, though, set their own expectations on hours, and those that on a chronic basis don't live up to expectations in the strong firms are counseled out. There's a culture that doesn't permit that kind of underperformance on an ongoing basis. I'll just also say that many firms are adopting the GE model. GE is famous for sweeping out the bottom 10% every year. Many strong firms divide into quartiles the performance of their partners. And the lowest quartile, those that are chronically underperforming the firm's expectations, are often counseled out, sometimes with exceptions. But that's often the rigor with which firms look at performance. One other thing I would say is that it's the strongest firms that do this on an ongoing basis and don't wait for years and years and then have to do a very large cut. Most firms have a built-in culture. Most strong firms have a built-in culture of doing this on an ongoing basis. One other thing they do, the strongest firms set measurable and achievable but aspirational goals for their performance. So for example, on profitability, a firm will say, okay, over 3 to 5 years, here's where we're going to be in profits per equity partner. And then they reverse engineer their rate structure and their productivity levels, and therefore their capacity in terms of number of attorneys to get to their targets. That's how well-run firms often manage themselves.
Yeah, it's interesting. You talk about firms doing this over the period of time in the past. That said, it's usually done quietly without a public announcement, kind of the way Weil Gotshal did. They didn't announce it in a press release, but the New York Times came out with a full article discussing the cuts. Going forward, do you see firms continuing to do it on a quiet basis, or is this something that's going to be a little bit more public?
I think some firms will continue to do it quietly, but I will say that I hear from many chairs of firms who saw what Weil did And the perception is they managed what they did very well. They controlled the message in the media, that's the perception, and they were able to tell the story at a time and in a way that they wanted to tell it. So they get high marks from a lot of firms that I talk to in the way that they handle their cuts.
I got to say, I'm a little bit surprised. Part of me is surprised that we're talking about cutting back partners in big law at a time when there are signs that corporate America is starting to find its footing and become a little bit more healthy. Why are the partner cuts coming now, just as firms' clients are starting to be on a little bit better footing financially?
Many of the firms that are cutting now didn't cut earlier, immediately after the '08 crisis. The ones that cut then often have less to cut now. Many of the ones who cut now didn't cut for whatever reason. For example, at Weil, they were handling the Lehman Brothers bankruptcy, so they didn't have an overcapacity issue until now, and they addressed it now. The strongest addressed it early, often, and on an ongoing basis. It's really those that didn't address it earlier that need to address it now. One other point that I would make. It's the strong firms that focus on the higher rate work and keeping overcapacity to a minimum. Other firms aren't as focused on those things, and their performance shows for it.
At a lot of large law firms, firing a partner requires a full partnership vote. Are firms actually conducting these votes? It sounds like it might be difficult to pull off, or are they generally finding other ways to push partners out?
They find other ways to push them out. What I would tell you is that it rarely comes to a partner vote. In the strong firms, there's an expectation on both productivity, on book of business, on some other metrics. And when partners aren't meeting those expectations over, say, a 3-year average period, there typically is an expectation that those partners will exit the firm. And if partners don't exit the firm on their own, usually all it takes is a conversation with leadership when leadership says, I'm going to have to recommend to the partnership that we ask you to leave the firm. And nobody wants to suffer that embarrassment typically. And so people typically leave well short of a partner vote.
Now, if you're a partner in this situation where you find yourself being pushed out, do you typically have any room for negotiation?
So what I would tell you is that people who are chronically underproductive and don't have a significant book of business that's profitable don't have a lot of leverage. However, most firms treat those partners with respect. They give them a severance period. And an important point I would make is this doesn't come as a surprise in well-run firms. Instead, there's a conversation that's ongoing with people who are underperforming. And there's discussion about how to get their performance up. And there's a window of time in which, a very reasonable window of time usually, in which to do that. And when it's not possible to make that happen, often firms give people the option of starting to look for a job while they're still at the firm before they leave. So this is usually handled with a great degree of dignity, and it's usually in well-run firms not a surprise to anybody.
Not a surprise. It sounds like it's better to be a partner than an associate when it comes to this sort of thing.
You know, I agree with you, and I'd also say that associates are starting to become known as an endangered species in many firms. And a big reason for that is that clients increasingly don't want to pay for first, second, sometimes even third-year associate works. Instead, clients are increasingly saying, you know what, those people don't know a whole lot right out of law school. They don't bring a lot of value to the table. We don't want to see them on our bills, they'll often say. And they also realize that there's alternative ways to get that work done at a quality level that's acceptable more efficiently. That's why LPOs, as we've talked about before, are really taking off now.
Partnership used to be like tenure at a university, almost a job for life, if you will. Has big law become more like a revolving door where partners have to constantly prove themselves time and again?
Big law hasn't necessarily become a revolving door, but it has become an organization that's run more like a traditional business. Another way to put it is big law has become a little bit more like GE. Instead of being able to have tenure no matter what your performance, there's an expectation of strong performance for the length of a partner's career. There's much less tolerance for underperformance, even for senior partners that used to have an easy glide towards retirement, even if they weren't as productive toward the end of their career. There's not as much tolerance for allowing that easy glide anymore. Instead, like GE, firms are increasingly looking at the bottom percent of underproductive, chronically underproductive partners and counseling them out of the firm.
Do rank and file partners at firms that you talk to, do they acknowledge this new reality?
Rank and file partners who are performing with strength acknowledge this reality and are often very bullish on it. Those that aren't recognize the reality less.
Some consultants that we've spoken to have said that big firms as a whole have 8 to 10% more partners than they actually need. How much overcapacity do you think is in the system?
So I think the common wisdom today in the industry is it's at about 10% on average. However, I would throw in a caveat that's important. Really, what your capacity, overcapacity is and what your ideal capacity is depends on what you want your performance to be. So if you want a certain level of profitability, say $2 million, you might need to constrain capacity further than if you want profits per equity partner at 1.6 million or 1.5 million, something lower. It has to do, you need to triangulate between rates, capacity, and productivity in order to know what level of overcapacity you have and what you need to deal with. So it's relative to the firm's aspirations on performance to know how to get capacity right.
Interesting stuff. Kent, thanks so much for stopping by.
Bet.
If you'd like to learn more about the issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube. You can follow our updates on Twitter. I'm Pacchia. Thanks for watching.